Uh-oh, you signed a non-compete when you took this job, but now you want to leave. And that document is sitting in the back of your mind telling you that you cannot work in your field for the next 2 years. Here's what your employer is counting on, that you're actually going to believe that. Non-compete agreements are one of the most misunderstood documents in employment law. The fact that you sign one does not mean it is enforceable. The fact that it is in your contract does not mean a court will uphold it. And in 2026, the law on this topic has shifted dramatically in employees' favor. I'm going to show you exactly what makes a non-compete enforceable and what makes yours not worth the paper it's printed on. Here's what you're getting in this video. First, I will walk you through the 4 tests courts use to decide whether a non-compete is actually enforceable, because most employees have no idea these tests even exist. Second, I will tell you where you stand based on your state, including which states have effectively banned non-competes entirely. And third, you will get your to-do list, the specific steps to take if you want to challenge yours. If you find this useful, then please hit subscribe. New video every Tuesday on the legal stuff most employees don't know they need to know. I'm a lawyer. I've seen non-competes enforced, I've seen them thrown out, and I have seen companies threaten employees with non-competes they had no legal basis to enforce. Let's get into it. Key insight number 1. What's a non-compete? Let's start with what a non-compete actually is, because it is often confused with 2 other agreements that get bundled into the same document. A non-compete agreement restricts where you can work after leaving your employer, which companies you can work for, in what geographic area, and for how long. That's different from a non-disclosure agreement, which restricts what information you can share. And it's also different from a non-solicitation agreement, which restricts your ability to recruit former colleagues or contact former clients. A non-compete is the most aggressive of those 3 documents. It can prevent you from working in your field entirely, and courts in most states scrutinize them carefully before enforcing them. Key insight number 2, the 4 factors. In states that allow non-competes, courts do not just rubber stamp whatever the employer wrote. They apply a reasonableness test, and there are 4 factors that determine whether your non-compete passes it. Factor 1, legitimate business interest. The employer has to have something worth protecting. Trade secrets, confidential client relationships, specialized training. A non-compete that exists just to keep you from leaving with no real protectable interest behind it is harder to enforce. Factor 2, geographic scope. A non-compete that covers the entire United States for an employee who only worked with local clients is overbroad. Courts look at whether the geographic restriction is proportional to the employer's actual market. Factor 3, duration. The shorter the duration, the more enforceable the clause is. 6 months is generally more defensible than 2 years. Courts in many states have specific outer limits. Factor 4, consideration. You have to receive something in exchange for signing it. At hiring, the job itself is usually sufficient. But if your employer asked you to sign a non-compete after you were already employed without giving you a raise, a promotion, or other benefit, well, that agreement may lack adequate consideration and could be unenforceable on that basis alone. Coming up next is an on-screen graphic with a detailed look at those 4 factors. Key insight number 3, the Federal Trade Commission. In 2024, the Federal Trade Commission issued a rule that would have banned most non-compete agreements nationwide. It would have affected nearly 1 in 5 American workers. However, federal courts struck it down. The FTC appealed, and in 2025, the current administration pulled back from defending the rule entirely. There is no federal non-compete ban in effect as of 2026. What does that mean for you? Well, that means that state law controls everything. Your rights depend entirely on where you live and work. This is important context because many employees heard about the FTC ban and assume they were protected. They might not be. Your state is what matters. Key insight number 4, different states, different laws. 4 states have effectively banned non-competes: California, Minnesota, North Dakota, and Oklahoma. Your non-compete is unenforceable in these states, regardless of what it says. California goes even further. It will not enforce a non-compete even if you signed it in another state, as long as you now live or work in California. A growing group of states only enforces non-competes above salary thresholds. Colorado requires you to earn at least $130,000. Illinois requires $75,000. Washington, D.C. requires approximately $162,000, the highest in the country. If you earn below your state's threshold, your non-compete may be void, regardless of what it says. Washington State enacted a near-total ban taking effect in June of 2027. Tennessee added a rule effective July 2026, prohibiting non-competes for employees earning under $70,000. Utah, as of May 2026, banned non-competes for healthcare workers entirely. Most other states still allow non-competes, but apply the four-factor reasonableness test. Florida is the notable exception. It enforces non-competes aggressively, and courts there are not permitted to weigh the harm that the employee may suffer. Coming up next is a more detailed graphic showing different non-compete laws in different states. Key insight number 5, the blue pencil doctrine. Here is the thing nobody tells employees about non-competes. In many states, even if your non-compete is overbroad, too long, too geographically wide, covering too many roles, a court does not have to throw it out entirely. They can just rewrite it. This is called the blue pencil doctrine. Courts in states like Georgia and Texas have the authority to modify an overreaching non-compete, to shorten the duration, narrow the geography, or limit the scope to something they consider reasonable, and then enforce that modified version against you. On the other side, some states apply an all-or-nothing rule. If any part of the non-compete is overbroad, the whole thing is void. California, Minnesota, and North Dakota take this approach. Knowing which doctrine your state applies is critical before you decide how to challenge a non-compete. Key insight number 6, challenging a non-compete. If you want to challenge a non-compete, here are the 4 approaches that actually work. First, check your state. If you're in California, Minnesota, North Dakota, or Oklahoma, or if you earn below your state's salary threshold, you may already have grounds to disregard it. Second, look at the consideration. Was this non-compete presented to you after you were already employed without any additional benefit? If yes, it may be unenforceable for lack of consideration. Third, look at the scope. A 2-year duration covering 5 states for a role with no client contact or trade secret access. Well, that's an argument for being too overbroad. I have seen employers threaten enforcement on non-competes they knew wouldn't survive judicial scrutiny, simply because they counted on the employee not knowing their rights. Fourth, negotiate. I have seen more non-competes quietly dissolved through a direct conversation than through litigation. Your employer may not want to spend legal fees enforcing a questionable agreement. Here's your to-do list. 5 steps before you make any move. Step 1. Read your non-compete. Note the duration, geographic scope, and exactly which roles or companies it restricts. Step 2. Look up your state's current non-compete law. Is it a state that bans non-competes? Are you below the salary threshold? The link in the description has the current 2026 state-by-state tracker. Step 3. Check when you signed it and what you received in exchange. Post-employment non-compete with no additional benefit may be unenforceable for lack of consideration. Step 4. Evaluate the scope against the 4-factor test: duration, geography, legitimate business interest, and proportionality. Step 5. Consult an employment attorney before you leave, start a new job, or tell your employer anything. Free initial consultations are widely available. Non-competes are one of those documents that feel more powerful than they often are. Employers know that most employees will never challenge one, even when the law would support them if they did. If you are sitting on a non-compete right now and wondering whether it is actually enforceable, drop your situation in the comments. What state are you in? What does the restriction say? And if this was useful, then please hit like and subscribe. New video every Tuesday. And if you want to know how to negotiate a non-compete before you sign it, so you never end up in this situation in the first place, I covered that in episode 6. It's linked above.